So if you're brand new to the landlord-tenant game, you may find yourself wondering, what could possibly go wrong on my very first eviction? If that's you, you're gonna wanna stick around because I'm talking all about the ways that evictions fail. Let's get started. So one of the big reasons that I have work at all is because people come to me with evictions that have gone nowhere. Either they started and fell flat, or the landlords come to me and said, I'm just not sure how to get this thing going, and it's been 5 months. If that's you, I want to offer a lifeline, because there are certain things that happen that are very, very common, but 100% preventable. And so I'm going to give you those keys and kind of show you what landmines you can avoid as you go through this process. Now understand that things could still go wrong. I certainly can't account for the kinds of things that the tenant might bring up or that the judge might require that have nothing to do with reality or the law, but at least you're not going to trip over your own feet. So when it comes to failure in an eviction, there are basically 3 things that happen. First, there are procedural failures. Then there are factual failures, and then there's just plain Murphy's Law. For a procedural failure, it's something having to do with a rule. Maybe there is a misinterpretation of that rule, or you just didn't follow all of the required steps, probably because you just weren't familiar with them. When it comes to the facts, well, that's one of those things that if your facts aren't lined up or they're not presented in a way that is going to win your case, you can lose a case based on what the facts bear out. And finally, the Murphy's Law kinds of losses, those are just going to kind of happen. It's hard to prepare for them, but if you are prepared, you're less likely to be devastated by Murphy's Law when Murphy comes a-knockin'. So I want to start off by talking about 4 procedural things that could go wrong, very predictably, do go wrong all the time for landlords who are trying eviction out for the very first time. Now, if that's you, if you find yourself for the very first time filing an eviction or contemplating an eviction, or maybe you filed 1 or 2 that went easy peasy, but this one's a doozy, I've got some news for you. For those of you, particularly in the state of Texas, I have an eviction course. It's called Texas Eviction, step by step from start to finish, where I'm going to guide you through the whole process. I have a video course with 6 modules and a 39-page ebook that walks you through everything from notice to filing, even to judgment. And so I'd like for you to take a look at this. If you're interested in purchasing this course, you can go to attorneyeg.com/EV for more information. So let's get started by talking about procedural problems. One procedural problem that happens all the time is that the landlord names the wrong people in their eviction. I know, it sounds silly, but sometimes there are more players involved and it makes things a little confusing on a procedural level for the landlord. For example, you might have a case that's managed by a property manager, or you might own a property management company. And so if you're set up in this way, you might confuse the participants who actually signed the lease. If your property manager signed the lease in their own name as landlord, but you're going to handle the eviction and file it under your own name, you might be the owner, but you're not a party to that lease. Just the same, the entity that you filed that owns the property may have their name on the lease, but again, you sign in your own name that eviction petition and list yourself as the landlord. You might again have a procedural problem there because the wrong party is in place. I'm not going to get deep into the legality of it and why in the law this is a no-go, but just by putting in the wrong party, you're going to cause yourself all sorts of problems. Look at your lease. That's the best place to start. Make sure that the named landlord is the name that goes as the plaintiff in your eviction petition. But those aren't the only names to consider. You also have tenants. And the law in your jurisdiction might require you to name all of the tenants who signed the lease. That's definitely the case in Texas. And so if you've only mentioned one person, but 3 people signed that lease and all of them are still in possession, you might not get your eviction. And getting your eviction kicked out because you didn't put the right names on the paper is a very, very silly reason to lose your eviction. Make sure if your jurisdiction requires every tenant who signed the lease who remains in possession to be listed in that eviction petition, you put their names down. Let me know in the comments below if this video has been helpful to you. Give us a like if you've enjoyed it. And if you haven't subscribed yet, please consider subscribing. Sometimes you file the eviction in the wrong courthouse. Hey, you don't know, and not everybody knows exactly where they're supposed to file. In Texas, you are limited to the precinct in your county where the rental property is located. It has nothing to do with where you live. It has everything to do with the precinct where the rental property is located. Make sure before you file in the right courthouse. You don't want to file an eviction in a court that doesn't have jurisdiction. You're going to want to ask that fundamental question first: am I filing in the right courthouse? But I guarantee you, lots of landlords get this one wrong because they jump before they really see where they're headed and they land in the wrong courthouse. And so by doing this, you're just going to cause yourself unnecessary delay. Make sure you're filing in the right courthouse. Give them a call and just ask, I've got property X located at this address. Is this within this court's jurisdiction? Yes or no. Pretty simple. It doesn't take a lot of time. Don't file too early. If you give a notice that says you've got 3 days before I'll file, make sure you wait all 3 days. So many times I've seen landlords give a notice and say, you've got until date X, but they jump the gun for whatever reason. They get really anxious and they don't wait for that date to come and go. And by filing too early, you're likely going to cause yourself a procedural error where the court's going to say, sorry, you didn't give enough time, you filed it too soon, go start over. Another problem that happens pretty commonly is a defective notice. Maybe something you said threw the whole thing off, or maybe it's something you didn't say in your notice that throws the whole thing off. In any case, if your notice is defective, either in its substance or the way that you delivered it, you risk getting your lawsuit thrown out in the eviction court. A defective notice can be a poison pill. But there are all sorts of other things you could screw up to send your eviction into the toilet. Among them are the factual errors that you could commit. Among them, you just didn't raise a big enough deal. So it is possible that you're in front of a judge who sees a non-rent lease violation as not a big deal. It might be a huge deal to you, but if the eviction court doesn't see that the thing you're asking for is really that bad, they may not grant your eviction just on that basis. Let me give you an example. Let's say that your tenant has not cut the grass to your satisfaction. You issue a notice, but that notice isn't a please do it right next time. You go straight for a notice to vacate because you believe that the extra half inch of grass is a substantial basis for you to evict. But the court might 100% disagree with you and say, why are you here for this small problem? You got your rent, you got it on time. You may say, Your Honor, I am frustrated with this tenant who won't cut the grass the way I've instructed them to do. And that may be 100% true, but you're not going to win that eviction, not on that basis. And so if it's just not a big enough deal for the court to kick somebody out on the street, it's okay. You're going to lose that one, but you're better off knowing where that line is. I like to tell landlords, look, if you've got non-rent violations, have at least 3 instances of them. I teach a 3 strikes and you're out kind of rule. And so that if you can demonstrate to the court, even if 1 or 2 of those by themselves wouldn't get the job done, perhaps after 3 violations, you can convince the court. And I say perhaps because it might be that the 3 that you choose, again, just don't amount to enough in front of that particular judge to win the day. So make sure that you've got something substantive that you're going to present to the court that's going to justify your demand for that tenant to be removed. It's frustrating when this one happens, but it does happen. You show up to the courthouse with nothing and the tenant shows up with a stack of documents. You're probably going to lose that one. And it's not because the court favors giant stacks of documents, But if you present your case in a way that lacks credible evidence, but the tenant presents very credible evidence that contradicts your statements, naturally that's going to weigh more in the court's eyes than your verbal recall of what actually happened. You may say, Your Honor, I have not received rent in 3 months, but they show 3 money orders in the exact amounts of rent. Now, whether you got them or not is a different story, but if you didn't bring a rent ledger with you, if you didn't bring notices that you sent over and over and over to them indicating non-payment, that could really be a problem that is not going to work out well for you. Make sure that when you show up to the courthouse, you show up prepared with evidence to prove your case to the judge. So another thing that landlords get wrong is they file with an improper basis. This might be because the lease doesn't mention the thing that they're claiming is a violation. You might, for example, say they had their music way too loud, but if your lease doesn't say anything about that, how could it possibly be a lease violation that would entitle you to cancel the contract? If it's not in the lease, you can't cite them for that particular violation. Another common error is that you cite something that the court doesn't even allow as a basis. For example, in the state of Texas, you can't evict someone for non-payment of late fees exclusively or for non-payment of some repair, even if the tenant was 1,000% on the hook for. The fact of the payment is not itself something you can claim as a non-payment basis. Now, sure, these things are violations, but if that's not the basis that you cite, if what you're citing is you want to recover money from them, and now that you're terminating on this basis, the court's likely going to turn you away. Because if the rule says you can recover possession for these things, but you cite things that just aren't in the rules, even if it's in your lease, the fact is you're going to be turned away because you have an improper basis filed with that court. The last improper basis has to do with retaliation. If what you're doing amounts to retaliation, which is a complicated thing, if the only reason you are actually evicting isn't because of a valid basis, but because the tenant is exercising their rights and you just don't like that and you're looking to send them packing, that's not going to be valid. And in the state of Texas and in many other states, you could find yourself on the wrong end of a retaliation claim where you're having to pay attorney's fees and court costs and possibly even economic damages. Don't just retaliate and use the courts in this ugly way. If you've got a problem with your tenant, resolve it outside of the court. Don't use eviction as a mere weapon. Now, if you've got a valid basis, that's a different argument. I'm talking about those instances where you have no basis and the eviction that you filed is purely retaliatory. Bad idea. Why did you accept rent after you issued a notice to vacate? Why did you accept rent after you filed your eviction petition? These kinds of things are likely going to wreck your eviction. Is it possible to accept rent and still proceed with an eviction? Sure it is. But man, do you put your eviction at risk by doing this. Not only does it look shady, but if you don't have the proper documentation, if you don't have a clear communication with your tenant that yes, you're accepting this rent, but yes, you are still proceeding with the eviction, that's not going to look good in front of a court, especially if the tenant talks to the court and presents to them that your agreement was in exchange for accepting this money, you would dismiss the case. Again, whether that happened or not, you kind of set yourself up for failure by taking money after a notice to vacate or after the eviction was filed. Doing this tends to wreck your eviction because factually it just doesn't look good. Is it possible, again, to paper this transaction properly? Yes, but you're likelier going to get it wrong than you are going to get it right. Also, when you have a non-rent issue with your tenant, sometimes on the day of trial, they'll show up and everything has been rectified. The tenant has completely cured as of the date of trial. Well, what do you do then? Well, unfortunately, if what you said was they didn't cut the grass, they didn't move the trash cans from the front of the yard, and they punched a hole in one of the walls and didn't repair it. But they show up with photographic evidence of all three having been completed. The judge may turn you around and say, I don't see a problem here. Looks like they took care of all of it. So the truth is, you might get your eviction kicked out on that basis. So don't be surprised if the tenant in fact cures all of those defects. You may find a losing eviction to be in your future. Finally, and this one happens when you're just not careful with your documents. You might have a lease that requires all sorts of extra things that your state simply does not require. Probably because you had it drafted by someone who lives in a totally different state. And I'm not saying that you hired anybody to do this, but you may have gone and Googled your way into a problem by finding a lease that's not really appropriate for leasing in your state. And because your lease requires additional steps that your state doesn't require, you may ask someone, hey, how do I do X, Y, or Z? And all the while, your lease itself is going to hang you because you followed the proper procedure, but for the extra stuff in your crazy lease that isn't appropriate for your state. If the tenant brings that up, or if the court reviews your lease in the eviction process and says, hey, wait a minute, you were supposed to give an extra this, or you didn't give as many days as this lease requires in your notice to vacate. And if that's your case, you might have an eviction that sinks right to the bottom. Make sure you understand what your lease requires of you every single time you file an eviction. Now, because your case is brought in front of a real person, a judge, that judge may interpret the law in a way that you are just not used to. The fact is, you may go to the exact same court every single time you present an eviction, and this time the judge was sick and a replacement judge was there, and that judge's view of the law differs from the judge you're used to. And so different judges may look at the exact same facts, review the exact same procedures, but come to a very different conclusion. Some will interpret the law more broadly than others. Some will interpret it more narrowly than others. Whichever is the case, you may find yourself on the losing end. For example, there are certain judges in the state of Texas who will not allow you to issue a notice to vacate for fewer than 3 days. Now, 3 days is the default, but the code in Texas allows a landlord and tenant to agree to a lesser amount. And some leases do allow for a 24-hour notice to vacate in the state of Texas. But not all judges like that rule. And so they interpret their reading of the rule so narrowly that the only valid notice is a 3-day notice to vacate. Not necessarily true, but if that's how they rule, that's how they rule, and you kind of just have to deal with it. So when you're dealing with Murphy's Law, you have to understand that anything that can go wrong will eventually go wrong, and it might go wrong for you in the eviction court. Among these is the behavior of the tenant, and it could have a drastic effect on your case in a trial, because sometimes tenants cry and sometimes they lie. Now, the ones that cry sometimes cry with a really good and compelling reason. It might be that someone is really sick or that someone's recently lost a job. And if you acted in a way that the court sees as maybe callous or a little too aggressive, again, the fact that you have the right to do it may not be enough for the court to stomach such an eviction. You might get your case thrown out simply because the tenant has a real tearjerker of a reason why that rent wasn't paid. And unfortunately, there's just nothing you can do about that. Now, it is possible to avoid this sort of thing by, working things out and communicating with your tenant. If you have evidence that they were not communicating with you or maybe even grew hostile to you, that's something that maybe you can share with the court. But sometimes you're just going to get stuck, and no matter what you say or do, the court's going to find in favor of that tenant. This also happens when they don't tell the truth, or they stretch the truth, or they just flat out lie. I've seen this happen before. I once had a landlord testifying in a case that he personally delivered the notice to vacate into the hand of the tenant. But the tenant claims, no, they never got that notice. In fact, she said, I lifted my hands just like this and never touched the paper. Now, my client testified that's not true. Not only did I hand it to you, but I posted it on a door. I even hung a flyer on your car. Well, the door posting and the flyer weren't enough. They're not technically allowed in Texas law under these circumstances, but the court focused everything on the personally delivered copy and said, you know, I find both of you equally believable, but because you, landlord, didn't convince me more than the tenant, you did not meet your burden of evidence, which was to prove more likely than not that what you did actually happened. And because I found you equally believable, I'm denying your case and making you start the whole process over. Oh, it was a heartbreaker because had you just put it in the mail, totally different outcome. But the testimony was, I placed it in her hand, and her testimony was, no, you did not. So no matter where you are in your landlording journey, I hope that you've enjoyed today's video. YouTube seems to think that this video right here is the next best thing for you to watch. Enjoy it, as well as all the other content on this channel. And until next time, landlords, happy leasing.